Uh, First of all, I would like to congratulate the team of Academic Excellence in IDNU for coming up with this unique idea of video blog. I believe this will surely go a long way and will help students at large. Hello, I am Ankit Tripathi, a student of 4th year from the Constitutional Law Honours. And in this video, I shall be discussing about the issue of right to privacy in India, along with its evolution through various international conventions, by dissecting the recent Supreme Court judgment of the Justice K.S. Puttaswamy versus Union of India and others, by referring to the possible impact of this case on the Aadhaar scheme, which is a government-sponsored scheme. This year, in the month of August, the Supreme Court bench, comprising of 9 judges, including the Chief Justice of India, unanimously held that right to privacy is a part of fundamental rights guaranteed under Part 3 of the Indian Constitution. It was held that Article 21, covering the life and liberty, gives the way to right to privacy. Before we move ahead in this discussion, I shall be giving you a brief overview as to what would be discussed in this video. We would be discussing the meaning and scope of the word privacy, then the evolution of the right to privacy doctrine in India, then we'll go to the judgment which has been pronounced recently by the Supreme Court. Then we shall be discussing the possible impact of this judgment on the Aadhaar scheme, and in the end we'll see what would be the way forward of this particular judgment. To begin with the meaning and scope of the word privacy. Friends, if you see the word privacy internationally and in India as well, this term has not been defined very categorically in any sense. Privacy is a term which does not have a definite understanding. There is no clear-cut definition of the word privacy anywhere in any law, any doctrine established. If you refer the Black's Law Dictionary, it defines privacy as right to be let alone or right to live from unwarranted interference by the public in the matters in which the public are not necessarily concerned. Now, this was the definition which was also referred by Justice D.Y. Chandrachud in his judgment when he was categorically holding that right to privacy is a fundamental right. He referred the Black's Law Dictionary to define as to what do we really mean by the word privacy and what would it mean if this is given the status of the fundamental right in India. Moving ahead, if we see the evolution of the right to privacy doctrine in India, right to privacy in India has been developed through catena of its decision in the past 60 years. Though there were certain inconsistencies also created with two of the judgments given by the Supreme Court, one in 1954 of MP Sharma versus Satish Chandra, and the other in 1962, that is Khadak Singh versus State of UP. Now these two cases have created certain inconsistency which led to divergence of opinion whether right to privacy is a fundamental right. Now with this recent judgment of Supreme Court of Justice K.S. Puttaswamy versus Union of India and others has reconciled those opinions and has held that yes, right to privacy is a fundamental right in India and can be given the status of the fundamental rights and become part of Part 3 of the Indian Constitution. Now, if you see the international concept of right to privacy through various laws of other states and the decisions of European Court of Human Rights, Court of Justice of European Union, and Inter-American Court of Human Rights, we can see that this right to privacy doctrine is not a very something new doctrine, right? So, if you see the Article 12 of Universal Declaration of Human Rights and Article 17 of International Covenants of Civil and Political Rights, we can see that it provides that no person shall be subject to arbitrary interference with his privacy, family, or correspondence, and everyone shall be having protection of laws from those interference. Now, this convention is ratified by India as well, and India is a party to this. Now, Justice D.Y. Chandrachud in his judgment categorically holded that since India is a party to this, it provided India need to have a law on right to privacy as of now, and it's too late that we don't have a right to privacy law. So it provided that yes, India can have right to privacy because India is a party to this ICCPR convention. Moving ahead, it also held that the constitutional provisions must be read and interpreted in such a manner that they are given conformity with the international human rights instrument ratified by India. Otherwise, there is no use of those instruments for which India is also a party to it. Now, if we see the different laws of other state and the other constitution of different state, when it comes to United States, they don't have a specific article which provides for right to privacy. When we go to see the United Kingdom, they don't have a specific law on right to privacy. Yes, the European Union does protect the right to privacy by the virtue of Article 7 of Charter of the Fundamental Rights of the European Union. So as far as all these nations are concerned, they do have some of the other indirect laws by which they go on to protect the right to privacy. And with the help of those doctrine, the Supreme Court tried to give an interpretation of the same in India as well. Now, coming to the judgment portion, the recent judgment of the Supreme Court in Justice K.S. Puttaswamy versus Union of India was a resounding victory for privacy. Now, this would be a moment in history where the long suppressed voice of the people finally found utterance. There were many people advocating for this right for a very long time. Though it was very predictable that the Supreme Court would be giving a judgment in the favor of the petitioners, but the Supreme Court went way beyond the expectation. When the Supreme Court pronounced this judgment, it was categorically held that right to privacy is part of life and personal liberty guaranteed to us by the Constitution of India by the founding fathers. Though it was argued by the petitioners that right to privacy is part of India Constitution, but it was very strongly rebutted by the government that the founding fathers did not include right to privacy in the Indian Constitution, and that was the reason that they did not wanted it to be a part of the Indian Constitution, as it cannot be defined, and the state should be having the full liberty to encroach upon those rights with reasonable restriction. But the judges were not in mood to accept those arguments of the respondent and the government of India. They accepted the argument of the petitioners that privacy is evolved through the dignity and liberty of an individual. Now, if you see the judgment, the Supreme Court did not create a new right when it gave out a verdict that right to privacy is a fundamental right. Unlike when the Supreme Court did it with the case of right to education. When right to education was given the status of the fundamental right, right to education was given a new article, that is Article 21A in the Indian Constitution. But this was not done in this case. In this case, it was held that the bench is merely granting recognition to an already existing right as the constitutional core of human dignity. It held that privacy, it is a private space, is a reservation of private space for an individual based on the autonomy of the individual. Now, this was the argument given out by the petitioners, which gave that yes, privacy is the reservation of the private space, by which they held that yes, right to privacy can be a part of fundamental right. Now, if you see, friends, privacy is a very wide concept. There are various complementary rights associated with this right to privacy, such as right associated with Section 377 litigation, rights associated with mass surveillance program, the rights associated with Aadhaar scheme. So there were umbrella of rights which were associated with this. But if you see this 547-page judgment, the Supreme Court judges have tried to not touch upon those rights, and they have left it for future judges to decide upon those rights, citing the point that our constitution is a living document and this would be decided on case-to-case basis as what would the other varieties of this right would mean. So all this has been left to the future judges very cleverly by this bench of 9 judges. Now, if we come to the exceptions of right to privacy, now if you see the judgment, there is no specific restriction created out for this right to privacy. But yes, like all other rights, it has been held that right to privacy is not an absolute right, and it has been held that right to privacy is not an absolute right, but it does not mean that it would be left to the whims and fancies of the government to encroach upon these rights as and when they'd like to do. To prevent this encroachment, it has been very categorically held by the Supreme Court that there would be 3-pronged test to test the encroachment of this right by the government, which is based on the principle of legality, necessity, and proportionality. This test would mean that any law which infringes upon the right of the privacy of an individual by the government must satisfy three requirements. Now, those three requirements are: first, there must be a law which provides for those encroachment or which justifies for those encroachment. Second, there must be a legitimate aim of the state for encroaching those rights. And third, the interference by the state of those right to privacy must be proportional to that aim of the state. If these three tests are being validated or being complied with, then that would mean that yes, the government has a power to violate those rights, and it is well within the ambit, and it would be intra-vires to the statute or to the constitution. Now, moving ahead, if we see that what does the Indian constitution and right to privacy means? Now, if we see the case, the Indian constitution doesn't provide for right to privacy. But when this case was being discussed, this particular case has not only touched the question of the specific issues of privacy, but it has stretched well beyond the specific issues of privacy, and it has ventured into the realm of life and personal liberty and the connecting threads of various other fundamental rights such as Article 14 and 19 as well. Friends, if you read this judgment, what has been very observant point of the Supreme Court judges is that when they were discussing the interpretation of life and liberty in this case, they emphasized the instance which was taken by the judges in R.C. Cooper case, where they held that the fundamental rights do not exist in silos. That means they exist as a part of indivisible unit, which would be rendered meaningless when they are divorced from each other. That means all the fundamental rights need to be read in harmoniously constructed manner. It has to be given a conjoint reading to have a better interpretation and have a better valid construction of any argument. It has been held that any law which impinges the liberty of an individual has to be tested on the ground of equality, freedom, and liberty. That means any law which impinges the liberty of an individual has to be tested on Article 14, 19, and 21 and has to be given a conjoint reading. Then only it will be possible to come up with a valid argument that yes, this law impinges on the liberty, or this law does not impinges on the liberty. Now, friends, if you ask me what was the very valid point, was there amendment required for this case, I would say that no, this is a work which is half done. Now, what is the next biggest point which people have been also discussing is, as of now, it's not very clear as to what would be the impact of this case on the government-sponsored Aadhaar scheme. Now, when we come to the Aadhaar scheme of the government, we see that, if you ask me, does it mean that giving the status of right to privacy as a fundamental right would mean that Aadhaar is unconstitutional, or will it be shut down? If you ask me in one word, the answer is no. How? I'll tell you. If you see the verdict, the legitimate aim of the state for which the government can violate the privacy of an individual includes, I'll quote unquote, preventing the dissipation of social benefits. The preventing the dissipation of social welfare benefits means, I'll give you what do you mean by dissipation. The dissipation means squandering of money or resources without following any proper method. So that means that government can come up with certain programs or certain identities program or certain value-added programs where it can dissipate, where it can prevent those dissipation, where it can prevent the squandering of those resources. And if you try to see this outlook, Aadhaar Act came in 2010 with a very objective that it wanted to achieve the objective that every poor people should have the reach to all those necessary items in the country. That was the objective of Aadhaar. If you see in this outlook, Aadhaar can continue to stay in the progress, and Aadhaar can continue to be a part of this, because Aadhaar is for providing the social welfare benefits to the needy people, and it would also prevent the further dissipation. That means that Aadhaar can coexist even with the right to privacy given a fundamental right status. It also means that it would also flourish to prevent the financial inclusion of all the people. Now, Next important point is the importance of data protection laws. My friends, if you see, as of now, many people who have been advocating for this right are happy that yes, right to privacy has been given a fundamental rights, but believe me, the work is half done. For better execution and implementation of this particular law in India, we require that there must be a robust data protection law. I repeat, for better execution and implementation of this law, that is right to privacy in India, we must be having a robust data protection laws so that all those people who are having our data are held accountable. Otherwise, there would be of this law would be of no use. So, in the coming days, we expect the government who is having a particular team, who the team has been already formed to work on those areas and come up with the data protection laws. So, to conclude, friends, I would say that the work is still half done. The judiciary has done its job by giving the right to privacy a fundamental right status. Now, the ball is in the hands of the parliament. It is the work of the parliament to come up with a strong data protection laws so that we can give a more and we can come up with we can have a very strong data protection laws, unlike in other countries. And there are many countries like USA and other people which have the laws on data protection, but India still lacks those laws. So at the end, I would say that it is just the beginning of right to privacy in India, and the real test begins now when this particular law would be understood and applied in the various challenges, and it will also have to be seen as to what would be the consequences of this particular case on the emerging issue which is already pending in Supreme Court with respect to WhatsApp case, Aadhaar case, Section 377 case, the mass surveillance program. So let us wait and see what happens in the future. To conclude, I would say that you would like the video, and to have more reading on this, I would suggest that there are certain blogs, there are certain writers who are continuously working on this. If you want to see the data protection law, one of the member, the former Justice of Supreme Court of India, Justice B.N. Krishna, has already released a white paper on data protection laws, which has invited several comments from the stakeholders, which you can very well observe, which is there already there on the all the platforms, which can be circulated to you as well. You can see and give your valuable comments and input on those laws, what should be the law or what can be the law. There are people who are already working on this. There are advocates, there are think tanks, Wiki Center or Thinking. There are advocates like Gopal Shankar Narayanan. There are advocates like Dr. Arya Sengupta who are working in this direction. And the most important part is the international human rights obligation. The international human rights obligation given out by the people is very important, which has to be studied for culling out a very clever status as to what would be a fundamental right to privacy means. Let's see till then what goes on, and let's see and wait for the government to come up with data protection laws. Till then, thank you so much for watching this video. Thank you so much.